Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
All right, welcome back to another episode of Men's Divorce Podcast. Today, we will be talking about appeals. I'm Rick Julius, Senior Litigation Partner out of the Pittsburgh, Pennsylvania office. Today, I'm going to be joined by Dylan Briggs. Dylan is an attorney out of our St. Charles, Missouri office, also a member of our appellate practice program. Dylan, how are you today?
I'm well, thank you, Rick. How are you doing?
I'm doing well, Dylan. Thanks for joining us. So one of the big issues that we always see come up in the course of a litigation is, what if we think the judge got it wrong? What if we got the order we weren't expecting to get? What if we just disagree with things? So one of the biggest questions that I'll ask you on this to go over with our listeners is, when is a case ripe for appeal?
Sure. To state it simply, a case is ripe for appeal when a party believes that an error was made by the trial court, and in response to that party would file an appeal with a higher level of judicial authority. In Missouri, it would be the Missouri Court of Appeals, and then an appellate court will determine whether or not a mistake actually was made at the trial level, and whether or not, because that mistake was made, new relief needs to be afforded. So the process occurs by each party filing a brief to the appellate court, which the appellate courts will review. They'll also review a record of what occurred at the trial, both in the form of a transcript and also copies of any exhibits that were admitted.
So Dylan, when we talk about the timing of this, I realize every state's different, and I'm only licensed in the state of Pennsylvania. You're only licensed in the state of Missouri. But what sort of timing would we be looking at for a client to want to come and talk to us about whether or not they should appeal a ruling?
Sure. It's actually, in legal terms, it's actually pretty quick. It's usually about 30 days after the entry of the judgment in the underlying case. So if someone has gotten a judgment that they're not happy with, it is imperative that they meet with a qualified appellate attorney as soon as possible, because not only do the potential client and the attorney need to meet to discuss the case, familiarize the attorney with the issues, but appellate cases are also very labor intensive. And so there's a lot of legwork that has to be done to get a case started like that. So it's imperative that clients afford themselves and their attorney as much time as is practicable after the entry of that underlying judgment to get those dominoes into place.
Okay, and I think that's a perfect time for a reminder that if you've gotten a ruling that you disagree with, or you just want to talk to somebody about whether you have a potential appellate case, you can always call 1-866-DADS-LAW or visit CordellCordell.com. We schedule virtual consultations as well as in-person, in-office consultations. We have 10 appellate attorneys who assist in the appeals process on top of the hundreds of attorneys we have in 35 states nationwide. So I want to remind everybody, 866-DADS-LAW or CordellCordell.com. Schedule a virtual consultation or an in-person consultation as soon as possible if you want us to take a look at your order and see if there's a possible appeal. So one of the next things I want to talk to you about, Dylan, is the difference between a sort of a do-over and an appeal. Because a lot of times we get guys come in and they say, well, the judge just got it wrong, or I disagree with it. Or, the cringiest one for me is, I don't think my trial attorney did a very good job, and now I want to appeal the ruling. So can you go over for the viewers a couple of the reasons why we would file appeals, and maybe some situations where we don't think an appeal would be meritorious?
Sure. The decision to pursue an appeal is something that should be heavily considered because, as I said before, they're very labor intensive. And because most attorneys bill hourly for their time, they're therefore very expensive or relatively expensive in terms of financial cost to the client. So we don't file appeals just because any old mistake was made, or even especially because we simply don't like the ruling or judgment that came down. I mean, technically, anybody can file an appeal for anything, but you should not want to incur the significant expense to do so unless you stand a reasonable chance of prevailing. So, consideration must also be given to the impact of any mistakes that occurred at the trial. So, if a judge made a legal mistake that the law says is incorrect, but it didn't really affect the relief that was afforded to either party, then it's kind of a tree falling in the forest that nobody sees. It doesn't have enough of an effect, so it doesn't justify disturbing the trial court's judgment. And getting back to your point about simply not liking the judgment or not being satisfied with your representation that occurred at the trial level, those are almost never going to be a basis for an appeal to be granted. You can't just not like a judgment. You have to have a legal basis to point to an error that occurred at that trial that the appellate court could say merited overturning the trial court's judgment.
Well, and I think one good point to that is that on an appeal, we're bound by whatever happened at the trial. And a lot of folks don't necessarily understand the idea that when a trial takes place, there are certain things that you need to have an advocate with the appropriate legal expertise to be able to establish that record for appeal. And I think a lot of folks lose that in the idea of maybe they go and represent themselves and they have no legal training, or they have a family friend or somebody who doesn't practice in this particular field of law go in and represent them. Can you identify maybe some of the mistakes that happen at the trial level that really hinder a person's ability to appeal their case?
Absolutely. Having qualified counsel at the trial level is the first and probably foremost step in having an appeal. Hopefully, you don't need an appeal because everything goes great at the trial level. But if it doesn't, it's so important that you have a qualified attorney there to preserve the record that occurred at that trial. So we're people, our lives and marriages, our lives are messy. My life is messy, but not all of that messy or not messy information is going to get presented to the trial judge. So at the trial level, the trial attorney and the client will distill down all of that information to the stuff that's most important to present to the judge. And that is kind of the essence of trial litigation. Appellate litigation is very different. So whatever actually happened in the world that was talked about at the trial is pretty much irrelevant on the appeal. The only thing that matters is what was in that record. And a trial attorney can have a significant amount of impact on what is and is not in that record. And so if an attorney has not, there's this concept called preserving an issue for appellate review. So typically you have to afford the trial court a chance to fix their mistake, but as a prerequisite to having the ability to get the appellate court to tell the trial court that that was a mistake. So good examples of those are legal errors. So those would be things like a misapplication of the law, for example. So a judge incorrectly applies an overnight visitation credit, even though the parent paying support is not eligible to receive that credit for some reason. So that would be an example of a legal error that misapplied the law. Another one would be an erroneous evidentiary ruling. So a judge improperly permits hearsay testimony, even though that hearsay testimony should have been excluded from the proceeding. Last on the legal errors would be procedural errors. So, one party fails to notify another party of a hearing and the court proceeds anyway. That would be another example of a procedural error. But getting back to that concept of not all errors being appealable or that you should appeal them. That hearsay example that I gave just a moment ago is a perfect example. So judges, rightly or wrongly, will let hearsay testimony into a trial pretty regularly. By the letter of the law, it might be that hearsay testimony should not have been admitted as testimony at that trial. But if it was just, he told me this thing, and it had no outcome or had no significant bearing on the outcome of the matter, then that's not something that an appeal court is going to say, the trial court screwed up. We need to have a whole new trial here because that one sentence of hearsay testimony was admitted. It's going to be an error of no consequence, essentially.
Okay. And what would you say to the listener out there, or the viewer out there, who's maybe getting ready for trial, or even sitting in the middle of their trial, and they start to see things like, I've given my attorney pieces of evidence that aren't being presented, or I wanted them to talk about certain things, or my attorney's missed some deadline that is now, prohibiting me from presenting evidence or somehow prejudicing me some way. Do you have any advice for those folks sort of on the fly?
Sure, absolutely. So if you're having that thought while you're sitting at trial, the horse has kind of left the barn at that point. So closing the barn door isn't going to do very much good. But in all of those other circumstances that occurred before the trial, in those instances, I think that in each one of them, they should go and consult with a different attorney about the way that their case is being managed to determine whether or not that case, it actually is being mismanaged, or inexcusable errors have been made, like missing time deadlines. The law is reasonably complicated, and so sometimes attorneys just do a poor job of explaining to their clients why they're doing things or why things are happening, which is not good or okay, but it doesn't necessarily mean that attorney is ineffectively representing that client. And so, hopefully you go meet with that other attorney, and that other attorney tells you, nope, the one that you got is doing a great job. But that other attorney could also tell you, I think we got some problems here. Here's some things we need to discuss. Here's some things that I would do differently. What do you think about those things? So that would definitely be my advice, is to, if you have concerns like that, I can't help you once the trial's done. You've got to come to us before the trial happens. Doesn't matter how good of an appellate lawyer I am. If your trial attorney has not done his or her job, my hands are tied.
Understood. That's great advice for folks. And I think that kind of brings us back to the idea of, if there is some level of uncomfortability, or you just want a second opinion, I would never hesitate to tell any of my clients, if they were uncomfortable with something, go get a second opinion, and that allows them to be more confident in my services. But if you're getting close to trial and you don't have that level of comfort that your attorney is prepared for, I would definitely want you to call 866-DADS-LAW or visit CordellCordell.com. Schedule a consultation with us. We'll go over how we would prep for that trial. We'll go over, reviewing your case and seeing where things are at. See if there's anything we can do to help you out before it's too late. Because, unfortunately, like you know as well as I know, Dylan, a lot of times guys come to us and that horse has already left the barn. So I want to double back now and kind of go over a little bit of what that process is. Now, we were talking about the 30-day deadline on things. Now, it's not the same deadline in every state. So, the first thing I want to mention is make sure you know your state's deadlines for post-trial or appellate filings. Some are shorter, some are longer. But, using that sort of 30-day process as a template, can you describe kind of what goes into the idea of the legal work and preparation for the appeal within that 30 days?
Absolutely. Well, the first thing is to meet with the client to understand the nature of the appeal. Oftentimes, clients, unfortunately, don't bring copies of their judgment to their consultation. So that would be my first strong suggestion, is that you make sure that you bring a copy of your judgment to your consultation with your appellate attorney. Then the in that consultation, the appellate attorney will kind of discuss initial impressions of the error that is being presented by the potential client. but it's going to be difficult for the appellate attorney in that environment to offer informed advice on the appealability of whatever issue the client is bringing to the attorney's attention, because while we have the client's perspective on what occurred at the case in the trial, remember that whatever actually occurred in the world doesn't matter. All that what matters is in that record. So it's kind of a litmus test at that first appointment. We as the appellate attorneys, we know when we're barking up the right tree and when we're barking up the wrong tree. And so if we're barking up the wrong tree, we're probably just going to tell you that it's better if we don't help you. But if we think that we might be barking up the right tree, then the next step is to go out and get a copy of that record. So we need to get a copy of the transcript or all of the transcripts that are relevant to the judgment. And we also need to get a copy of all of the exhibits. And we need to have an opportunity to review those materials. And oftentimes, in a one-day trial, that transcript might be 250 pages long. And reading through it once probably is not going to be enough. If you have some cases have 20, 40, 50 exhibits that also have to be reviewed, internalized, and incorporated into the analysis on the propriety of pursuing an appeal. So once that record review has been accomplished, the appellate attorney and the client would meet again to discuss the work product of the attorney's efforts in familiarizing him or herself with the record, and the attorney can offer much more concrete and articulatable advice on the prudence of proceeding with an appeal. So hopefully upon that record review, the attorney and the client will agree that it is an appealable issue and that the client wants to proceed with the appeal. And so the first step, at least in Missouri, and I think it's very similar in most states, is to notify the trial court that you intend to appeal the trial court's judgment, and we do that by submitting what's called a notice of appeal to the court. And so that's kind of the starting gun, if you will, on the appeal. And appeals are very time-sensitive actions. So there's a lot more deadlines that have to be complied with in appeals than in trial cases, and all of those time deadlines are kind of triggered by that filing of the notice of appeal.
So I think that's an interesting point that I want to kind of focus on for a second there. So let's again use that 30-day deadline. Let's say that you have the most egregious ruling on the planet with so many legal issues that it would be the easiest appeal on the face of the planet, hypothetically.
And I love that. Come see me.
And then you wait until day 31 to file that notice of appeal. What happens with your appeal?
It's gonna turn my stomach. I mean, I live for appeals. I do trial work kind of as a privilege for for the ability to be able to work on appeals. And if you came to me and you presented these issues and I was rip roaring and ready to go, and then I looked at that judgment and we were one day past the time deadline, I would say crestfallen would probably be a good adjective to describe me, because, like I said, the time deadlines are very rigid in appellate law. A lot of times, we can go to a trial judge and say, yeah, judge, I know there was a time deadline, but come on, you can help me out here. And a lot of times, rightly or wrongly, they will. That is not the case with the appellate courts. They do not have that same patience for a failure to comply with their rules. They wrote them, they're very proud of them, and they expect you to comply with them.
So day 31, you're out. So, time is of the essence when we're talking about all of the preparation work and everything that goes into a potential appeal. So certainly don't wait. If you want us to take a look at your case, to schedule a consultation, come in, let us start that process, because it is certainly not a easy process. It's certainly not a quick process.
And what a lot of people don't realize is that there can be a pretty significant delay in when the judgment is entered and when that client even receives the judgment. So, in Missouri here, it's not uncommon for a judge to sign a judgment and that be the date of the judgment, but it doesn't actually get published to the attorney on the electronic filing system for 3, 4, 5 days after that. Then the attorney's got to take a couple days to process it, get it out to his or her client with a letter, typically discussing the judgment and any potentially appealable issues. And so by that time, we might already be 10, 15 days down the road. And as I said, 30 days, really, I mean, it is enough time, but we would love to have more time. So if we're already down to 15, you need to be racing to get that consultation.
Well, and I think that's an excellent point too, because I've had so many guys in the past come in and say, well, the judge ruled from the bench and kind of told us what it was, and then I got the order in the mail 2 weeks later, and I didn't even open it because I knew what he said, and then it turns out there's all this stuff in it. Now it's day 28. What can you do to help me? So I think another really good tip, particularly for folks that, unfortunately represent themselves, for one reason or another at trial, that you really have to stay focused and hyper focused on the dates that are attached to things, when things come in the mail, when things are mailed out, when they're filed, and all that, and pay very close attention. It's not just something as simple as, day 28, you hire an attorney and then, he's going to make things all better.
Yeah, that's going to be a tough pill to swallow. I would do my best, but it would be challenging.
So one last thing I want to talk about and go over with the audience is kind of what the outcome of an appeal could be. I think there's a little bit of a misconception, and maybe that's more so at the federal level, the stuff that makes the news, how things are overturned or laws are struck down and that sort of thing. It doesn't quite apply to the area of domestic or family law, in that when you appeal a case to a court of appeals or a superior court or an appellate court, what are some of the outcomes you would hope to achieve or reasonably expect to achieve if your appeal is successful?
Sure. So the appellate courts do have a pretty broad toolbox that they can use to make changes to the trial court's judgment or the proceedings that occurred in the trial court. But as you were alluding to, in family law, they're kind of limited in the number of tools that they can use. So let's take a child support case, for example. The court enters a child support order that's $850, and my client believes that his child support obligation should have been $250. And after I review the record, I tell him that he's right and the judge screwed up. And we appeal that to the appeals court. Most people, I would think, would, if the court was going to agree with us and say that the trial court made an error, most people would think that the appellate court would just say, okay, well, you've already presented us with what the child support obligation should be. So the appellate court is just going to tell the trial court, you put in the wrong child support number. We're putting in this child support number into the judgment, and now we're all done. That is very rarely what happens. What more often will happen is that the appellate court will tell the trial judge, you made an error in your calculation of child support. So we are overturning that child support calculation and the child support order that stemmed from that calculation. And we're remanding, which means sending the case back to the trial level for additional proceedings on the issue of child support. So then the parties, the attorneys and the judge will all have to come back to court, and additional testimony and evidence will need to be presented on the child support issue so that the judge can conduct his analysis and issue his ruling to be congruent with the appellate court's directive. So usually two ways that appellate courts do things in family law. Seldomly, they actually change the language of the judgment themselves. Much more often, they remand the case back to the trial court for additional proceedings by that trial court judge.
Well, and I think that's one very important thing to keep in mind when we're making the decision and we're analyzing whether or not to file an appeal. There's always that cost-benefit analysis that's associated with things. And I think there is that misconception that, as long as we win and we get it right, then it'll be a worthwhile investment to things. But we always want to factor in the idea that, potentially your best case scenario is that remand back to the trial court level, and we still have to prove your case again. Now, obviously, you're in a better situation, whether that's with us representing you or with a favorable ruling at the appeals court, but it's not always necessarily kind of the end of the road to things. So that's one thing you certainly want to ask about. Certainly, we can go over with you in the consultations. Certainly, after you retain our services, we'll always go over what we think the viability will be, and allow you to be able to kind of evaluate that cost benefit of going through that process. Last thing I want to go over for the viewers would be sort of an expectation on time frame. And I realize it's super speculative and that there's different standards for custody, divorce, maintenance support, that sort of thing. But can you shed any light on the time frame from, say, the date of the filing of that initial notice of appeal to when a client might expect an order from the appellate courts?
Sure. The 30-day deadline that we talked about earlier with respect to filing the notice of appeal, there is going to be some difference there, but it's largely right around there in all the different states. Once we get into the administration of the case, there's a lot more leeway and difference in the amount of time when certain aspects of the case are due. So I have to file a notice or a brief after I file my notice of appeal within either 90 or 30 days. But I could, if I don't have enough time to get it done in that time frame, I can ask the appeals court for an extension. And almost always on that first request for an extension, the appeals court is going to grant it. This doesn't usually happen with me, but if I, for some reason, still didn't have enough time to get it done the way I wanted by the time that extension deadline was coming up, I could submit another request for extension. And sometimes that one's going to be granted too. But those extensions can happen at each stage of the case, except for that first filing of the notice of appeal. No extensions on that. Typically, it gets wrapped up within about a year. We hope for something closer to like 6 to 9 months, but with extensions and multiple extensions, that's kind of my expectation for the total case duration of an appellate case.
And it's important to remember too, you're just one of the attorneys on it. So, that if the court is granting extensions, typically, they take the approach of what's good for the goose is good for the gander. So if you're asking for, a 30 or 60 day extension, odds are they're going to expect you to consent to a 30 or 60 day extension for the other side's brief on things. Now, you touched briefly upon a shortened deadline for child-related matters. Now, as
Yes.
I understand, a lot of states have similar laws, at least to the extent that they sort of fast-track issues related to custody, some even for child support. Can you touch base real quickly on that?
Absolutely. So in Missouri, I have to file my appellate court brief within 90 days of when I file that notice of appeal, unless one of the issues that I'm appealing pertains to matters related to children. So typically child custody and child support. If I'm appealing those issues, I've got to submit that brief within 30 days rather than 90. So the court places more urgency on matters pertaining to children, as we should all hope that they would.
Okay, so they sort of jump you to the front of the line to make sure the kids don't get caught up.
Exactly.
So, well, Dylan, I really appreciate your time today with us. I think we went over a lot of very important stuff, and I hope anybody out there watching or listening really takes it to heart that this is a very serious element of their case that really doesn't just start with the final judgment. It really goes into the preparation for what their trial consists of and how they prepare for that, as well as addressing those post-trial issues. So I want to remind folks, there's plenty of other episodes of Men's Divorce Podcast on our YouTube channel. I invite everybody to, again, call 866-DADS-LAW or visit CordellCordell.com. Schedule a consultation with one of our attorneys in 35 states. If there's any questions that we can help you out with, one of our attorneys in those states, will be able to get you pointed in the right direction. So, Dylan, thank you.
Thank you, Rick. And as I said earlier, I do trial work for the privilege of being able to do appellate work. So to everybody listening out there, if you've got a potential issue that you think that you can help me do what I love, I hope that you'll reach out to us. And I have 9 of my colleagues on the appellate team with me. So you may be concerned that we might not have an appellate team attorney in your state. However, if we have any office in your state, then we'll be able to help you. So we can essentially work with the local attorney in our office there in that state and give you the qualified appellate representation to which you're entitled and you should be seeking.
Awesome. Thank you, Dylan.
Thank you. Take care.
Take care.